topic is investigating electoral malpractices, the key principles. Um, I want to just delve into the Nigerian situation, and I'm using the Electoral Act of 2026 as a framework for my paper. Uh, the electoral landscape in Nigeria has been a lot, like we heard from the prof and from the former registrar, Mr. Olomu. We have gone through a lot, and then in Nigeria, we everybody is affected by politics and elections, but it is not everybody that takes time to be interested in what goes in. Now, there have been several laws before the Electoral Act of 2026, but my focus is the 2026 Act. It's a legal framework that creates provisions for elections in federal, state, and local government. It also establishes the Independent National Electoral Commission as a corporate entity. It also provides for registration of voters, what mode of election should be held, whether it's secret ballots, open ballots, and it also includes the electronic transmission of results. It defines the legal requirements for a political party, what you need to carry out a legal campaign, the financing limits, and the code of conduct for electoral officers. It, it includes provision to deter violence, religious affiliations, and other political sentiments that characterized our elections before now. So quickly, because of the time I have, I want to I want to go into some of the things that constitute electoral malpractices. Because if you don't know what the electoral malpractices are, you wouldn't know what to look out for when you are investigating. Some key malpractices provided by the Act of 2026 is non-disclosure of party affiliation. So somebody cannot be in multiple parties now. Any person who is a member of political party and misrepresent themselves by failing to disclose this is liable to a punishment and a fine of 5 million naira or 2 years imprisonment. Misconduct or dereliction of duty is another malpractice. So an officer who engages in any form of misconduct, that's especially a polling officer, an electoral officer, ad hoc officers too, people who are engaged in carrying out election. If they do any form of misconduct or dereliction of duty, they are liable to a fine of 2 million or a term of imprisonment. Then you have um, multiple registrations. People, sometimes back, some people will they will just be announcing the votes of some states. Then some states will just come as if they use a trailer load to bring the ballot boxes, ballot papers. They will be in millions. But I was looking out for such states in the last election, and I saw that probably because we now have the beavers or the IREV, the votes that come in millions don't come in millions again. In fact, they struggle to be in hundreds of thousands. So multiple registration and all that is the law is trying to deter it by providing it as an offense. It's also anybody found in such acts can be liable to a term of 1 year imprisonment and 100,000. Then we have people having multiple cards, multiple voters card, buying and selling of voters cards. This one particularly attracts 5 million naira fine or imprisonment. Hindering registration or forcing people to vote under duress for your party or coercing people, issuing threats and all that. There are a plethora of offenses provided in the Electoral Act, and and but I want us to focus more on understanding the principles behind these offenses and even the act itself. The act itself is to strengthen democracy to a large extent, that even if people come, because we know it is a normal thing. In fact, lawyers look forward to election season because there will always be litigation, there will always be dissatisfactions after an election. So people are, the law is trying to protect democracy to a substantial effect. I mean, so that even if what the wrong complained about, or the malpractices a litigant wants to bring to the courts, is not substantive enough to deter democracy. It may not be, how would I put it now? It will not be that, oh, because you just have a case, everybody can come. So the law is already sifting out on its own what the ingredients of offenses are, what malpractices can constitute enough ground for you to file an election petition. And it has been provided that people who file frivolous petitions, or just want to come because they have the leeway to come to court, they are punished if they come with frivolous petitions, and that's also carrying a fine and imprisonment term. So, and then also the act is also trying to deter money and inducements, money democracy and inducements. So you see that to a large extent, they have provided election budget limits. For instance, the presidential election is 10 billion naira, and so on and so forth. Laws in itself are very good, but what what matters most is enforcement of laws. And then, if as an investigator or an officer, you really want to document things that will help a case, because you don't know what will become an evidence, what will become a piece of evidence. So as an officer or an investigator, what do you look out for? Or if you're a law enforcement agent, if you're an officer with the INEC, or you are just even a judex, that's the judge now, what are the ingredients that would constitute enough evidence for you to say there has been a malpractice? And so I want us to look at some few points. So as an investigating officer, you need to be able to understand that at the point of election, the mandatory transmission of electronic results is adhered to. That's using the IREV. Although the National Assembly is still saying probably transmission may where it may not be possible, and there's been a lot of uproar on that. If we can get our alerts in few minutes from bank transactions, why can't we get election results? I think I leave that for um for Boniface to answer. I don't know who Boniface is. Then, as an officer now, another key principle you need to see is that there are verification of results. That the party agent in the polling station, and the officer, the electoral officer there, and even the voters, everybody agree that this is the result. I think it should be counted and then transmitted. Then in the law now, there's public accessibility for electronic results. So we should also ensure that there's accessibility. So where all these are hindered, you begin to say, oh, something is happening. But and then we should also look out for the principle of substantial compliance. That's when you're evaluating whether a malpractice should invalidate an election, the law that applies is that, is there a substantial compliance? Look at the law, the electoral law. Was there enough reason to say, no, the time of voting is over, but it's because it rained before we could set up, but there was orderliness. That's substantial compliance. Or if there was no substantial compliance, for instance, somebody snatches ballots, disorderly behavior, there were weapons around, so you can't say that is a substantial uh, compliance. Please, can we hear me?
Yes, we can
Please,
hear you.
can we hear me?
Yes, we
Okay,
can hear
Yes,
sorry,
we can hear you.
you off
a
now,
trailer
ma.
just passed by me. Okay, so and then another thing is that, was there a secrecy of ballots? Of course, your our voting system is the open secret ballot. You have to be seen to be dropping something in the ballot paper, in the ballot box. I beg my. And then, was there compliance with the open secret ballot system? Of course, there may be people who are handicapped, people who are having a sight challenge and require help, even if they are being helped to the polling booths and somebody assists them, but at the point of voting, they should be allowed to vote by themselves. So no person can be thumbprinting for another in the name of, oh, I'm helping the person. Even if the person is illiterate, you can only show the person the voting process. Oh, thumbprint somewhere, but don't tell the person this is the party to to thumbprint into. So another thing that I want to, that will help us as investigators, if perhaps we want to establish that a political party is being funded, is exceeding their budget limits and all that, we have to be versatile in financial records investigation. We have to be able to look at their inflows. That's whether it complies with the 2026 Act. Are they receiving anonymous donations? You know, are they sectionalizing their campaign? Are they bringing in religious, ethnic bias, tribal bias? Are they whipping up sentiment? You know, are they receiving donations from religious bodies to, these are the things we need to look out for. Please, I apologize for that honking of horn. I'm in Lagos. Then we should also be able to, as investigators, to understand that our work will be questioned and cross-examined in court, and we should be prepared for that, because, like I said, no politician wants to lose an election. They go all out to win, and then they hire the best of lawyers to come and defend their election. And if you see the budgets for election petition, in fact, what they charge is really high. So most lawyers are battle ready to demolish your facts. So as investigators, we should be prepared to do our work diligently. Aside from being able to scrutinize financial records and then being able to document your processes, we should be able to, as investigators, understand the fact that court is a court of law. It's also a court of facts. And that because you are an investigator, you are an expert, even if you are not a lawyer, everybody in the court is seen as a minister in the temple of justice. So you shouldn't be, I don't want to use the word intimidated. You shouldn't be carried away when the fire of cross-examination comes in. If you have,
Mr.
uh,
Queen.
es- yes, ma.
No, ma, you should be rounding off now, ma.
Okay. I'm actually rounding up. This is about my last
All
point.
right, ma.
So my point is that you cannot be you shouldn't falter or under the fire of cross-examination because you have done your due diligence. And if you have done all your best and you have put your facts forward, even if the final outcome is not in favor of what you did, it is not also your case. I want to welcome questions and contributions. Thank you.
Thank you so much, ma'am. Do we have questions, contributions? Thank you for that wonderful session.
Yes, I have a question.
Okay, who else has a question so we
Yeah.
can take all the questions together and round off? This is a race against time right now. Okay,
Thank you very much.
all right. Oh,
Um,
go ahead, sir.
I'm Dr. Ibrahim Olusholani. I appreciate this presentation very much. From the question will relate to both a practical experience I had and a suggestion I want to make. I was involved in the local government elections, and a lot of things happened. One thing I came out with that experience is the fact that we need collaboration. Um, when Queen Oniwon was presenting, talking about we should not see our practice as just individualistic. And I believe that's why lawyers, you find that in election materials and petitions, you find 6, 7 lawyers coming together. But if you are just a single person, it can pose a challenge. And therefore, I'm advocating collaboration and also not working as individuals or in silos, but working as a team. And also the reality of our own uh, political environment requires that resources should be available. It appears that those people who have resources always have the upper hand. Thank you.
Thank you
That's
so
very
much, sir.
true.
All right. The issue of collaboration cannot be overemphasized. Mr. Ibrahim Zaid, do you have a question? I can see your hands up emoji.
Yes, ma, I have a question.
Okay, please go ahead, sir.
Thank you. Thank you so much, ma, Barrister Queen.
Thank you.
Uh, my, yes, my question is, you're a forensic lawyer now, so when you speak, you should speak like a forensic lawyer, not like an ordinary lawyer. So, so, so,
All right, sir.
so, as forensic experts in this platform, what do you think
Yes,
we
sir.
should watch out for? The specific things we should watch out for in terms of ballot paper investigation, so as to counter the issue of challenges faced in terms of cross-examination in the court of law. Thank you so much.
All right, sir. Any other question? All right. Thank you very much, sir. The
Okay,
issue
thank
of
you.
collaboration cannot be overemphasized. And thank you for giving me the title of forensic lawyer, but I'm first a lawyer. All right, then. That's on the lighter note. Um, Working in silos is not to the benefit of anyone, but it also becomes very important too if collaborating means collaborating to do the unlawful. You don't have to be part of it because somehow a camera is watching somewhere. We saw one video trending, which a court relied upon. of a particular polling unit where the local government chairman came into that polling unit and dislodged everybody, and a policeman was standing by, and together with the electoral officer, they stopped the ballot boxes and all that, and the court relied on that piece of evidence and other things to nullify the election and declare the opponent the winner. So if collaborating together means doing something unlawful, I don't think we should collaborate. And then we also saw one very distinguished academic, a professor, that is still going through the courts for criminal litigation based on declaring. Yes, I don't want to mention names as much as possible.
Okay.
I belong to the Christian faith, and the Christian faith says we should not join evil people to do evil. So that being said, in ballot paper examination, of course, thank God that Mr. Olomu's presentation came before mine, and we saw the things to watch out for. But when you are being cross-examined and somebody has stopped the ballot box, I don't think it's going to be possible in the future to do that because of Beaver's registration and all that, and then transmission of results with the IREV. But then you will still see some people who are daredevil politicians who wants to just do the wrong things. And now you are in court, you have examined that these things are true. You should be able to allow the court to know the process you used in arriving at your conclusion. And then you should be able to tell the court whether or not you are an expert in these things that you do. Then follow the rules of evidence in presenting your case. The rules of evidence, or especially electronic evidence, whether or not the means you collected it is according to the means that is in tandem with the Evidence Act. I think that's basically what you need. Of course, you would not just present your facts and not expect cross-examination, but you should always be able to stick out to what your fact is, and don't allow somebody to derail you and or get you emotionally attached. You know, when they get you emotionally attached, they throw questions that make you angry, lose your composure, they puncture your evidence to ridicule it before the court. That's the work of a lawyer, and that's the work of cross-examination. So you should be able to say, no, these are the things I followed. I am not obligated to answer every question except the court mandates you to. So when you feel that you are being harassed or taken out of your facts, you can ask to be protected by the court. And the court will do that. I think those tips will help. Thank you.
Thank you so much, Barrister Queen Oniwa, for that wonderful time, and thank you for taking your time to answer the questions. I want to say a big thank you to everyone for joining us. It's been a wonderful and insightful time, and we apologize that we are a little overboard. Thank you for joining us. I have few announcements to make, and I made some earlier, but I'll go over everything again. So our next induction is on the 30th of May 2026, and this is going to take place during our May workshop. So for anyone that is interested in becoming a member of the Forensic Investigator Society, please send your CV. Send your CV to contact FISN, contact.fisn, contact.fisn at gmail.com for more information. So you can send your CV to that email address, contact.fisn at gmail.com. or you can visit our website for more information on how to become a member, and or contact me as the registrar. My Can we hear me?
Yes, we can.
Okay.
Yes,
All
we
right.
can
Thank
hear
you.
you. Yes.
Or
Yes,
contact
we
me
can
as a
hear you.
registrar on my line on 081 3679 4453. 081 3679 4453. Also, you can visit our website www.forensicinvestigators.org.ng www.forensicinvestigators.org.ng. For professional forensic investigation courses, we have lots of courses tailored to make you a real professional in the forensic investigation world. So these training fees are flexible. We can make payment plans with you and make arrangements on how you can pay in installments if you feel you might not be able to pay at once. So visit the website for further information. Also, like I announced earlier, question document examination training would be starting this Saturday, 4th of April. Actually, for this cohort of training, we have lawyers for this cohort of training. So this training is specifically for lawyers. But if you want to join, if you are not a lawyer and you want to join, you can please reach out to us. We can add you to this cohort coming up, or you can wait for the next cohort. But the next cohort would be starting on the 4th of April. That's next Saturday. We'll be starting this training. Contact me or send an email to contact.fisn@gmail.com for further information. Thank you all